I am going to go ahead and call your case. It's Wayne Filizetti versus Gwinn Area Community Schools. It's a 15-minute mini oral argument on the application. Mr. James, you may attempt to reserve some of that for rebuttal, but we ask you to try and do that on your own. And if you're ready to proceed, please do.
Thank you, Your Honor. Yes, I'll reserve 2 minutes, Your Honor. Good morning. This matter stems from a very tragic accident that happened in September of 2015. The trial court, when presented with opposing motions for summary disposition on the case, did set forth a thorough analysis as to the stage, enclosure, and the wall panels within it as being fixtures of the building, and so did the Court of Appeals. However, as the matter progressed to the Court of Appeals, and somewhat to a lesser degree at the trial court, the cases of DeSanchez versus Department of Mental Health and Rennie versus DOT led the panels astray. In both of those cases, there is espoused a 5-element analysis of the public building exception. Unfortunately, that 5-element analysis omits significant components of MCL 691.1406 from consideration, and as a consequence, it significantly narrows the public building exception. Plaintiff appellant suggests in this matter that Section 1406 is better understood by the following 4-part analysis. 1, it is the obligation of the governmental agency to repair and maintain public buildings within its control and open for use by the public. 2, within a reasonable time of acquiring actual or constructive knowledge of a dangerous or defective condition of a public building, a governmental agency must remedy the condition or take action reasonably necessary to protect the public against the condition. 3, a governmental agency's failure to timely remedy or take action reasonably necessary to protect the public against a dangerous or defective condition of a public building shall result in liability to an individual for bodily injury or property damage resulting from the condition. And lastly, 4, knowledge of the dangerous or defective condition and time to repair the same shall be conclusively presumed when the condition has been shown to have existed or was of such condition so as to be readily apparent to an ordinary observant person for a period of 90 days or longer before the injury took place. The analysis I just outlined to the court incorporates all 5 elements that were set forth in DeSanchez and Rennie, but it goes on to fully outline 2 very significant components of the building exception, which are omitted by the DeSanchez and Rennie analysis. Those components were the second statutory duty of a governmental agency to timely take action reasonably necessary to protect the public against the condition, and 2, the statutory conclusive presumption of the agency's knowledge and time to repair a dangerous condition existing for 90 days.
Mr. James, let me interrupt you because I want to make sure everyone has a chance to ask you questions we can get back if they don't have. I'm going to start with Justice Clement.
No questions.
Justice Cavanagh.
I don't have any questions right now.
Justice Welch.
I do, Mr. James. I'm wondering, how would we distinguish this case from Wade, which involved a slick floor and transitory conditions? Why is this case not like that?
Well, Wade was a puddle on the floor. The puddle itself is not a condition of the building. In this matter, the condition of the building is the fixture. And therefore, the injury occurred because of the condition of the building. It is not a transient condition. It is a condition of the building. And therefore, the Wade analysis is not applicable.
Okay, thank you.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions, thank you.
Justice Bernstein.
No questions, thank you.
Okay, Mr. James, you may continue, and people will just interrupt you if they want to, and you can stop and reserve when you're ready.
Very good. So the failure of the 2 lower courts to assess these 2 components was an outcome determinative factor and thus requires reversal. An analysis of the facts in the case with a complete understanding of all components of the building exception should have resulted in summary disposition for the plaintiffs. In particular, is the May 29, 2015 school dude work order of Coach Sanavi, wherein he identifies a dangerous condition of the building existing because of the school's removal of the fixture, the wooden exclosure, the 2 wood panels from the alcove. It was Coach Sanavi's request that the dangerous condition be remedied by the wooden enclosures and padding to the cover be put back into place. As a consequence, as of May 29, the school district had acquired actual or constructive knowledge of a dangerous condition of its building. Those dangerous conditions would have been exposed angled iron brackets, exposed cinder block corners of the alcove, and a detached and unsecured fixture existing within its building, leaning against walls. Athletic Director Soren's testimony also supports that. He, quote, "But a terrible unsafe condition in your gymnasium as the athletic director stood in place from May 26th until September 3rd. That's a fact. That's on your watch as the AD. That's a fact." Then he says, "And what you believe was required to eliminate the hazard was the reinstallation of the enclosure within the alcove." True. As a consequence, 90 days from May 29, 2015 is August 27th. More than, I guess it's about 7 days before this accident.
Mr. James, can you,
Yes.
I think it's pretty clear that the panels were fixtures when they were secured to the wall.
Yes.
Why were they still fixtures when they were unsecured and removed?
A fixture doesn't stop being a fixture when it is removed. It remains
Isn't
to
it
be
sort of the nature of a fixture that it is a fixture because it doesn't get removed, right?
well. Therein lies the fact is that customarily for 10 years, this wall, that's the analysis of the fixture, is this wall is in place 363 days of the year and maybe down 2 days of the year to allow for the accommodation of a graduation ceremony. So it remains a fixture. Just because it's detached means it's an unsecured, dangerous condition because we have a fixture of this magnitude that's not properly secured and attached to the building.
Is there relevance to this analysis? Is it relevant, the particular nature of these panels, right? Like I know that there are Court of Appeals cases discussing, I think you have like a milling machine, right? That is maybe actually not even literally attached because it's so big that it can't get moved, right? And that is considered a fixture and an injury, and that is part of the building. I think there's even like risers or barricade or riser cases that are a fixture. Because they're so big to move, they don't typically get moved. So the sort of factual facts surrounding the item themselves, as well as how often it does, is that sort of the right analysis for that, as compared to, I think there's another case dealing with like parallel bars in a gym, right, that get picked up and moved every day, when gym is over, sort of thing.
Those are facts relevant, and they were discussed at length by the trial court. This object, that these panels, was part of enclosure. They weighed 325 pounds. They were supposed to have been moved by a group of 4 or 5 individuals. They fabricated special carts just to accomplish the movement of those because they were such cumbersome objects. They are affixed and are intended to be affixed year-round to be incorporated as part of the gymnasium wall to add the protection against exposed corners, and acted that way almost on an annual basis. To affix them properly, each side has 4 lag bolts, then they're affixed to the floor by brackets, then they are affixed in the middle by steel rods and brackets, and then above that there is a ceiling component which is also affixed to the ceiling with screws. This is intended to be affixed in a permanent incorporated into the wall. So I don't know how this could be likened to a chair or a ping pong table or anything else of that nature. This is a fixture attached to the building that they took out as part of a maintenance practice, which then required them to put it back in a timely basis, and they failed to do so. So that's the reason why I say on the 90-day presumption is that the presumption conclusively establishes that not only they have that knowledge of the dangerous condition, but they had time to repair it. And it did not occur. And as a consequence of that conclusive presumption, I believe the trial court and the Court of Appeals erred in failing to say that there was a liability conclusively established. Then, if you want to say, when did they actually acquire knowledge as opposed to constructive knowledge as it relates to the specific risks of the fixture being unsecured, that would have been in August 22 is the only testimony that we would have from the defendants that acknowledged that Tracy Belisar saw these things laying all around and she couldn't believe it. And that she recognized that they needed to be put back into place. And for whatever reason, they were not doing so. So as of that time, she, AJ Filizetti, and Robert Soring had ample opportunity to take action necessary to protect the public from the dangers of the unsecured fixtures and or to actually remedy the condition. So I understand the argument to be of the defendant, we only had 30 minutes. Well, that's not the case. They had a whole summer and they had many opportunities to fix the situation. If application is to be grant in this matter, I would ask that the court consider the opportunity to reverse Rennie versus MDOT. I believe that the analysis of Rennie overlooks holdings within Bush and Reardon as it relates to the obligation of a public school or any building to remedy the dangerous condition. It is the purpose of the statute to remedy the condition and or protect against the public from that condition. It doesn't matter what was the cause or creation of that dangerous condition. And that was set forth clearly in the Reardon decision. Just quickly as to the gross negligence component of my application, I believe that the legislature has set forth a clear standard of conduct for gross negligence in which a governmental agent can be liable. That is, gross negligence is conduct so reckless as to demonstrate a substantial lack, not a total lack, not a willful act, but a substantial lack of concern for whether an injury results. Generally, once an actor's conduct, once the standard of care is established, the individual actor's conduct should then be assessed by the trier of fact, not by the court. So that holding, that was the ruling of Tallman versus Marksman, which was subsequently adopted by Jackson versus County of Saginaw by the Supreme Court. And I don't believe there's any justification for the judicial heightened standard of gross negligence as articulated by Tarley versus Crabtree to continue on. And then most certainly I don't agree with the Court of Appeals analysis, which even modifies the holding in Tarley further and distorts the legislative designed gross standard of gross negligence to be stand. I think that the case as it relates to the gross negligence needs to be reversed and remanded to the court for trial with instructions consistent to that. I'll answer any further questions.
Or reserve your 50 seconds.
There you go.
Yep. Mr. Mullins.
Thank you, and good morning to the court. This is a case in which I believe summary disposition was properly granted. The operative facts in this case I would maintain are not at all in dispute. This is a case of statutory construction in which there can be no claim unless the school failed to repair and maintain a known defect in the building itself that existed for an unreasonably long period of time. There was no defect in this 60-year-old building. This building was in its designed, built, and constructed state. There was nothing to repair. It's undisputed. Each piece of the building, each piece of equipment in consideration was in its intended, constructed, and utilized condition. Plaintiff's complaint is one against activity. He complains about the manner in which individuals moved a piece of equipment and adapted it to a use in this building. Those of you who are familiar with school buildings, this particular building, this is a multi-use building. It's used for graduations, it's used for meetings, it's used for sports, it's used for practices, and different pieces of equipment will be moved into and be moved out of the building depending upon which activity is occurring. The equipment which is put in or taken out doesn't change the nature of the building. It doesn't change the ability to use the building. It doesn't change the value of the building. And contrary, respectfully, to what plaintiff's attorney has suggested, it was not intended to be permanently affixed to the building itself. In fact, the facts make it very clear that it was taken out and removed and taken out and removed. Just as Justice Welch indicated, this is transitory. This is something taken out and moved. In fact, the panels aren't in the building now. It's still the same building. It's still used for the same purposes, and those aren't there. But the inherent concept, nature, design, use, and value of the building is unchanged today, even without the panels being there. They're not there. That's a matter of record.
Mr. Mullins, let me interrupt you and see what questions are out there, and then we can come back. Justice Clement?
No questions.
Justice Cavanagh?
When the panels are affixed, are they a fixture? I mean, when they're installed, are they part of the building?
I think the argument could be maintained. I would say no. I would say they're like the parallel bars that are wheeled into the room in the case where they're wheeled in, screwed down into the floor, and when you're done using them, they're unscrewed and taken out again. I would equate these, for those of you who I'm sure familiar, having attended many.
Do the panels go anywhere other than either affixed to the wall, or, I mean, the panels are there to, I get that the stage comes in and out, right?
Well, no.
But the panels are supposed to, I mean, it's not like you take them out and you put them somewhere else.
Yes, it absolutely is.
It is? Okay.
The panels are taken out and they are put down a hallway, kind of something of a dead end hallway down by the CAD room. And that's actually where they had been for months prior to this 30-minute incident that we're talking about. And what I was about to say, I would equate these to, when I was a custodian, it was very common for me, and I'm sure you're all familiar with, you'd have these big carts and these very heavy cafeteria type tables, or that will be wheeled out into a room. They'll be set up. They might weigh 100 pounds apiece. I can give you 50 different transcripts of workers' comp cases where custodians talk about how heavy those things are, and they wheel them all out and they set them all up, and the building is used. They have these big long trolleys with the chairs in them that'll be hundreds of pounds, and you bring them out and you set them up. And when you want it to go back to be a gym, and you're done with your graduation, or you're done with your play, or you're done with your meeting or your board meeting, they're all put back on the cart and they're put back to where they are stored. That's what these panels are. They're really no different than those tables or those chairs. And this case would be no different if I was at a board meeting and the custodians set up some of those heavy 100-pound tables on the stage, and the board all sat there, and it was too close to the edge of the stage, and the panel fell down into the crowd and injured somebody sitting in front of the stage. That's what you're dealing with here. It's that same kind of a thing. It's a piece of equipment moved in, set up, moved out, depending upon.
But when they were affixed, they were the wall, right?
They were a barrier underneath, just like a basketball standard. I would equate these to, I've had cases involving volleyball standards where there's very, very heavy weights under what holds up the volleyball net. You wheel them out, you set it up, you have the volleyball game, you wheel them back up, and those weigh hundreds of pounds. I've got a case where a girl lost half of her foot because one of those fell over on her foot. And that's what these things are, moved in, moved out, set up, taken out. So A, it's transitory, but B, and most importantly to the statute, there's absolutely nothing defective about them. Every single characteristic of these pieces of equipment were exactly what they were intended to be. There is no defect. Installation and activity is different from maintaining or repairing. There's no maintenance occurring here. There's no repairing occurring here. It's just a matter of setting these things up and installing them. So even if you characterize them as a fixture, it doesn't matter. There's no defect. There's no danger. It's the activity of rolling out those cafeteria tables, rolling out that volleyball standard, rolling out those hundreds of chairs. It's that
But this
activity.
didn't happen when they rolled out or when they moved the walls, right?
It happened in the course of 30 minutes when they were rolling this out, setting them up, and getting ready to put them in. It would be as if you had the table on its side and you were ready to roll out the folding legs and fell over. It's the activity of setting up this equipment that is under criticism.
Okay, thank you.
Justice Welch.
So just carrying forward what you were discussing with Justice Cavanagh, what if the panels were actually installed and one of them fell apart from the wall and fell on somebody? What then? Would there be any liability or potential liability?
Well, I suppose the question would be what caused them to fall. So I mean.
Assume it's not like a tornado.
I
Perhaps
understand.
it wasn't attached properly.
If you had a brick wall, or I'm looking up and there's a light fixture above me and we can see that, I mean, this is what I understand and have dealt with the public building exception to be. I can see that this light fixture above me is hanging loose and there's a couple of loose screws and it's hanging 6 inches down from its framework, and you look up there and it's like, oh geez, I can see that might fall down and hurt somebody. And so a day goes by, a week goes by, a month goes by, and nobody fixed it, and I knew that was there and it looked like it was going to fall. That needed to be fixed. It wasn't in its design, constructed, and intended condition. It was a known defect that wasn't repaired. It presented a danger. I would agree with you. That's what the public building exception is meant to do. If I'm going up, the kids are going up and down the stairs, there's a railing that is shaky, 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 and you can see it's ready to fall, and everybody realizes some kid's going to slide down that railing, or it's coming loose, and it's not going to prevent somebody from falling down the stairs. You know it, it's there, it presents a known danger or cognizable danger, and you don't fix it. That's what the public building exception to governmental immunity. It doesn't guarantee safety in the buildings, it guarantees safe buildings. And so if there's a defect and you're aware of it, you fix it. There's no defect here.
Okay, thank you.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions, thank you.
Justice Bernstein.
Hey, counsel, it's good to see you again. Welcome back.
Yes.
I just want to engage you just a little bit. I kind of just have one question. It's more kind of a synopsis question, and I think I understand your argument. I just kind of want to make sure. But
Sure.
The idea here is that you've got a 350-pound panel, which is pretty massive. It takes about 4 people in order to kind of, put the panel kind of into place. You have a gymnasium that was active and kind of filled with people. You had a situation where one of the custodial folks basically, upon the time that the panel fell, said, oh my God, is it the panel? Because this was unbelievably dangerous. And you ultimately had a situation where, the plan was going to be that the panel was going to be left in its current position over the weekend for an extended period of time. And I guess, I understand kind of the 2 main issues that we're kind of debating. But I mean, ultimately, I can appreciate your argument that it's analogous to a large table that you would set up and kind of take down in the lunchroom, or analogous to a board meeting where the table kind of falls off the stage. But I mean, looking at this, and again, you know my kind of philosophy on this, looking at this again from a commonsensical approach, from kind of the way an ordinary person would see it, right? Wouldn't it be fair to say that in this situation, a panel of this size, requiring this amount of people, requiring this much work, it being left in a situation where you have young people who are, you know, kind of within that proximity for an extended period of time, from kind of like an ordinary person standard, wouldn't you say that satisfies the requirements here?
Well, Your Honor, with all due respect, I'm afraid you have the facts wrong. There was no intention. There was no intention that they be there that weekend. This whole matter, it's undisputed. This whole thing's, they wheeled these in between the time they were wheeled into the room and the time the accident occurred was like 30 to 40 minutes at most. That's number one. Number two, there was no plan whatsoever that they remain in that condition. One panel was taken in, the other panel was taken in, then Tracy Belazar went to get, she got some hardware, and then she went to get somebody else to finish the installation. This was all, the record's very clear. Number one, this is normally done by a couple of kids. There's only two people that were going to be involved, and it was all going to be over in half an hour. So there wasn't a long period of time. The record's very clear on that. It's established. There's no dispute on that. And it just so happens that somebody who wasn't there, Tracy Filizetti, Stacy Filizetti, left the gym where she was running the cheerleading practice, left everybody unsupervised, got her children, brought them back unbeknownst to anybody, and sent them off to the other end of the gym. But we're talking about a half an hour or less. Number two, the fact that he has some weight doesn't change the fact that it is, as I just talked about with numerous different examples, it's very, very common with the multi-purpose room for custodians to set up and take down and set up and take down and set up and take down many different objects of equipment. And that doesn't make it a defect. You're just changing the use of that, whether you have the big freestanding, as you've seen, I'm sure, basketball courts, nets, that weigh hundreds and hundreds, if not thousands of pounds with the counterweights on them. Or like I indicated, the cafeteria tables that weigh hundreds of pounds, or the chairs, or risers. In a multi-purpose room like this in a high school gymnasium, uses and pieces of equipment are constantly being taken in and being taken out. This is an activity. This is not a building defect. This is not something that is part of the building. It's equipment in the multi-purpose room in a very short period of time. We talked about failure to repair. Number one, there's nothing to repair. Number two, we're talking about less than an hour. Number three, the individuals are actively engaged in setting up these protective panels. An uninstalled object cannot be a fixture. I mean, a pile of shingles sitting outside that are ready to be nailed to the roof are not a fixture. A pile of lumber that you're going to rework a classroom in that is sitting out the side and delivered but hasn't yet been installed to put a new wall or divider in is not a fixture. It's a piece of material.
Counsel, thank you so much. You've done an excellent job with that clarification, and I appreciate your argument. Thank you.
Certainly. I'd be happy to entertain.
You have 22 seconds or 18 seconds, Mr. Mullins.
I'm happy to waive them if I've answered all questions.
Thank you very much. Mr. Janes, you have a little bit of rebuttal time.
Your Honor, the distortion of the record that was just made by counsel is extreme. First off, I need to clarify, because he makes a representation to the court that panels are not there and everything's just back to normal. That is not the case. The panels are not there, but in its place has been applied to both corners of the alcove new padding. The stage is no longer there. And on the back wall, there is new padding. The reason that this structure was built in the first place was because the exposed corners of the gymnasium presented a risk of the building. The storage of the back wall and the stage presented a risk of the building. So as the court observed, trial court at page 4 of her opinion, it said Exhibit 5 to plaintiff's motion was price quote for materials, and the panels were described as for, quote, direct wall permanent mount, close quote. That was the purpose of these panel enclosures, was to correct a defect within the building, and therefore these wall panels were to be incorporated as part of the building to alleviate those risks. They were there permanently, except for a brief period of time each year to be taken down, but they were there to be the wall of the gymnasium to protect the student athletes. As it relates to these arguments of counsel of extraneous tables and other objects that may be moved around, that's not what this object is. It was there permanently, has no other purpose other than to protect that location. And as he says, because
Counsel, can I ask you, I know because we're really out of time, but I just want you to clarify on the record. I think there's a little dispute. The timing.
The timing of the day's events?
Yes. I mean, I guess there's some dispute over this. If you can just make it, I just want to hear your position on that.
The fact is that in May, it's identified that these fixtures were removed and a dangerous condition existed. Constructive notice should have been, we have fixtures that have been removed and leaning in the back hall. That is the dangerous condition of the building, as well as the angle brackets. So we have a period of 90 days. But then if you want to go to this knowledge, their acquired knowledge of the specific risk of having panels leaning within its building, unsecured, that occurs on August 22 by testimony Tracy Belisar, where she says, these things are leaning all over the place. That's not how you do it. And as a consequence, you can't condense it down to this 30-minute time frame like counsel wishes to do, because there was a recognition of the risk of unsecured panels being the source of risk in August 22. So that is where they trigger the obligation to remedy or take action. This is not a situation where shingles or some other object causes injury. This is a fixture of the building that caused the injury. There's no dispute about that.
Thank you, Mr. James. We've used up more of your time than you had. Thank you both for your arguments today. The case will be submitted.
Thank you.